Hi, everybody. I'm about to record a guided voiceover PowerPoint on the Second Amendment, and I'm hoping that you will watch it because Second Amendment law can be a little bit complicated. And I apologize ahead of time if you hear any background noise. I have an older dog who's recovering from surgery here on the enclosed porch with me, and I can't just put him in another room because he needs me to keep an eye on him. All right, so let's get into it. So we'll save you a lot of headaches because Second Amendment law can be somewhat complicated. So, what is all this controversy over the Second Amendment and what the Second Amendment means? Well, let's look at the wording of the Second Amendment first. And here is the entire amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So it's worded kind of funny, not exactly the way we would write or talk today, but this was written over 230 years ago, so the verbiage is going to be a little bit different. But even for that time period, the verbiage can be open to communication. So look at that introductory clause, a well-regulated militia, comma. Because of the way the sentence is structured, it led to hundreds of years of debates. Did the founding fathers mean that this gives only the militia the right to bear arms, or that it only gives citizens the right to bear arms, or both? And then another thing to think about that some people will argue is that regardless of what the founding fathers intended back then, should we adopt a different meaning now in light of current times? So those are your two basic interpretations. There are some other interpretations that aren't so obvious. This first bullet point is an interpretation that a lot of people have. Individuals do have the right to bear arms, but the government can institute some basic restrictions, and those restrictions do not equal infringement. So somebody who believes in this first bullet point on this slide, the first argument, which is kind of like a mixture of the different interpretations shown on the previous slide, would say, hey, we can have limits on the First Amendment, right? You can't sell, pornography right on the newsstand, right out in front where you can, have just about anybody grab it. We have restrictions on pornography, just like we have restrictions on speech where you can't yell fire in a crowded theater. So likewise, you can have some restrictions on the Second Amendment and it's not an infringement. So that's what the interpretation for the first bullet point would be. The second bullet point would be the argument that would be condoned from people like the National Rifle Association, and they believe pretty much any gun control laws are an infringement on the Second Amendment, and that it can lead to a slippery slope, like when in Nazi Germany they took away everybody's firearms and then nobody had any freedoms. So that's another interpretation. As far as the claims made and the parallels and analogies that are derived from what happened in Nazi Germany, those don't really pan out when you fact check them, and you can look at the copy of this PowerPoint link to the handout section and check that out for yourself. So as far as traditional politics behind both sides of the gun control argument, you probably know that liberals generally are more in favor of gun control, and conservatives are generally more against gun control. But those are really broad overstatements, and there are many exceptions to this. But just to give you a framework. So what we're basically going to look at are a handful of federal laws passed by Congress, and we'll look at a handful of cases that the Supreme Court has decided, and at the same time keep in mind that each state also has its own gun control laws. So within the boundaries of what the federal government says the states have certain freedoms. So we'll talk about the first one, the National Firearms Act of 1934. And this was the first law that said, it might seem funny that it was this recent as 1934, that firearms have to have a registration number on them, along with these other basic concepts. So if you have a fully automatic firearm, a rifle or shotgun that has a length under 26 inches, along with these other types, firearms that have suppressors, that there has to be some sort of registration. At the time, historians pretty much conclude that this wasn't for crime control or gun control as we know it today, but it was mostly to generate revenue. The next major federal legislation was the Gun Control Act of 1968, which essentially said you can't transfer firearms between states, interstate, except among licensed manufacturers, dealers, and importers. So in other words, you can't go between the states and engage in firearms transfers. They want you to be somebody who's licensed to do so in order to accomplish that. And the main goal was to prevent private sellers from dealing firearms privately across state lines and working around any state regulations that might be in place. And some states even had a rudimentary system of background checks during that time. And it also banned interstate sales of guns to minors, drug addicts, and quote unquote mental incompetence. Language we wouldn't use today because that's pretty insulting, but what they meant by that were people with certain psychological conditions. We don't need to get into the detail. If you do Google that, they give you a pretty good definition of what they meant by mental incompetence. Pretty much people who had to be institutionalized, more or less. The next major act was the Firearms Owners Protection Act of 1986. And this banned machine guns, so gun control advocates like that, but they also didn't like this act because it did away with many prior regulations. And it created what's called the gun show loophole. So how that works is the Gun Control Act back in 1968 defined private sellers as anyone who sold fewer than 4 firearms during a 12-month period. But this act deleted that restriction and loosely defined private sellers as individuals who don't basically make their living at selling guns. So what ended up happening is in states where you can have gun shows, it created a gun loophole where one person could sell to another person and get around any state laws or background checks. Back then they had some waiting periods also because the background checks weren't instantaneous because we didn't have the technology. So this act essentially created the gun show loophole. And it also allowed for safe passage of firearms from one state to another, maybe from a state that has lax gun control laws to a state that has strict laws, as long as you kept the firearms in the trunk. So a lot of gun control advocates did not like this law. The National Rifle Association played a great part in getting this law passed. The NRA is a very powerful lobbying organization for gun control rights. They used to have a lot of money and a lot of power, although they're going through reorganization and bankruptcy right now. But they still have a lot of influence. They're technically defined as a nonprofit, but there are arguments and investigations about that. All controversy about the NRA aside, whether you like them or don't like them or think they're a good organization or a bad organization, you certainly would have to agree that they're extremely influential and have great power when it comes to getting laws passed or not passed. The Federal Assault Weapons Ban of 1994 was a law that banned semi automatic assault weapons. One big issue is what's an assault rifle and what's a semi automatic weapon and what's an automatic weapon. Pretty much any weapon you can think of is semi automatic, not automatic. A fully automatic weapon essentially means when you hold down the trigger, the the firearm still keeps going off and still keeps firing. You don't have to keep pressing the trigger. And those are very, very rare, except for, machine guns and certain weapons that the armed services have. And that's pretty much not anything civilians would have access to. People are essentially talking about semi automatic weapons being AR 15s and AR 17s. They are similar to, if you've ever heard of an AK-47, the military style weapon that you would picture, the silhouette you would picture if you closed your eyes and imagined a military type of weapon. And that's what this was intended to ban. And they are semi automatic. You have to press the trigger each time, so they're not fully automatic. Some of the controversy is that the definitions of what's an assault rifle can be kind of fuzzy. Some really innocent looking, hunting rifles that might look like something that was created 50 years ago and might look like it belongs in a cowboy movie might actually have more firepower and be more dangerous than some of these scary looking so-called assault weapons. So you can get into some arguments, and the NRA has raised most of these arguments about what's considered an assault rifle and what isn't. In any case, because of the different political battles surrounding this legislation, in order to get it passed, it only had a shelf life of 10 years and it expired. So that answers your question why. Because of politics, the NRA, the battle between gun control enthusiasts and people who are against gun control. It did have a grandfather clause, so people who already had such weapons could keep them in certain circumstances. So it's no longer in effect. So when you hear in the news all about, mass shootings with an AR-15 or 17, that's why. The Brady Act, which was passed in both 1993 and 1998, different versions of it, it instituted mandatory background checks and a 5-day waiting period, which we don't have anymore because now we have the technology of the National Instant Criminal Background Check. So depending upon what state, you could go in, show your ID, go through this instant check and walk out with a firearm. Or you could live in a different state where that's just the first step and you have to jump through a bunch of other hoops after that background check. So you'll see in a little bit, we'll compare and contrast some states that have stricter laws compared to states that don't have very strict laws. So Massachusetts would be an example if you wanted to do any research on your own. Massachusetts would be an example of a state that has pretty strict gun control laws, and like Texas would be an example that doesn't have very strict gun control laws. So regardless of what state you're in, you can't pass this background check if you've been convicted of a felony, if you're a fugitive from justice, if it is in the database that you have an issue with substance abuse or being institutionalized for a mental health condition. And those numbers 3 and 4 I'm talking about, how that information gets into the database can get pretty complicated, and can depend a lot on how your state submits that information. And there's some legislation that Democrats are trying to get passed that would standardize number 3 and 4. But for now, it's kind of all over the place. Certain undocumented people are also not allowed to obtain a firearm, and there are some miscellaneous provisions that pertain to people that are dishonorably discharged from the military and things like that. So, as far as current attempts at legislation, um, we're currently trying to get some laws passed through Congress, and those refer to ghost guns. And ghost guns, if you don't know what they are, it's basically when people can buy pieces of a firearm, um, as a kit, things that people will sell online on a website. Perhaps it's something people made with a 3D printer, and then people can assemble them at home. And that's a way that people try to get around the background check laws. So some of the current legislation has to do with ghost guns. Some of the current legislation has to do with red flag laws. And what those are laws that would allow somebody who's a relative, a spouse, a psychologist, a medical provider, any of those people who know that there's a current or emerging mental health issue or crisis that should keep somebody from owning a firearm, to report that to the appropriate people and have it entered into the database that would prevent somebody from passing a background check. Obviously, there's a lot of controversy over that and concern about that being something that could be misused. And in general, just expanded background check criteria. So, the National Rifle Association is currently going through bankruptcy because the Attorney General of New York investigated them for misusing funds where they're supposed to be a nonprofit. There was allegations that they were misusing funds for the people who were higher ups in the organization to buy themselves a bunch of trips and boats and things like that. I'm not saying that those claims are legitimate or not. I'm just saying that they're going through an investigation and the NRA is going through bankruptcy. There's talk of them, reincorporating in another state such as Texas. I have yet to see the results of that. If you wanted to see what kind of laws are being bounced around in the House and the Senate and that are all being backed by Biden, you can check out that link, and there's a copy of this in the handout section. There are also 4 cases that you can look at that are listed here. Going back way to 1939, we have a case, United States versus Miller, where this defendant Miller and his companion were put on trial and convicted because they carried a sawed-off shotgun over state borders, and the lower court upheld their conviction. The lower court ruled that their conviction violated their Second Amendment rights, and the Supreme Court of the United States disagreed and said that the Second Amendment does not protect an individual's right to carry a sawed-off shotgun. And I will fix where it says there twice right there. But it just established the precedent that you can't carry a sawed-off shotgun and that it's not a violation of Second Amendment rights to have a law that says that you can't. Lewis versus U.S. established the precedent that if you have a past conviction for a felony, it can prevent you from owning and carrying a firearm. And it led to the U.S. government banning felons from owning any firearms. And that precedent was established. DC versus Heller. This is one of the more recent ones you'll hear mentioned a lot regarding this issue. And this was an earth-shattering case, to make a huge understatement. And in this 2008 case, the Supreme Court finally articulated and finally spelled out that the Second Amendment not only applies to state militias, but also to individuals of the state. So in other words, they're looking at the Second Amendment, they meaning the Supreme Court of the US, and they're saying that there is an individual right to bear arms. And this quote comes right from the case. Therefore, banning handguns, an entire class of arms that is commonly used for protection purposes, and prohibiting firearms from being kept functional in the home, the area traditionally in need of protection violates the Second Amendment. So certain laws in DC that were making, handguns in and of themselves illegal, or saying that handguns kept in the home had to be kept in a dismantled fashion, that those laws violated the Second Amendment. So the mystery about which interpretation should prevail, well, we can have philosophical debates all we want, but according to the Supreme Court of the United States, they are seeing the right of an individual to bear arms in the Second Amendment. Things were further clarified in 2010 in the McDonald v. Chicago case that was decided a couple of years after Heller, where some people in Chicago decided to file suit because Chicago banned guns outright, just like the Heller case. This was a little bit different because what was at issue wasn't so much, do you have the right to own a handgun as an individual, because that was already settled with Heller. This was a case that pertained more or less to the incorporation doctrine. So the Supreme Court in this case decided that the Second Amendment was incorporated. And if you're trying to remember what the heck does that mean, we learned it at the beginning of the semester. What this means is that the right of the Second Amendment that the federal government recognizes, that an individual federally has the right to own a firearm, also applies to state governments. So in other words, an individual state or an individual city's municipal rules can't ban you from owning a handgun either. So remember, the whole thing with the Incorporation Amendment is, do all of these federal guarantees apply to states and cities and things like that? And when it comes to the Second Amendment, it does. So the total ban was removed in Chicago, and now you can even get a concealed carry permit, but not necessarily an open carry permit. I will fix that typo. Also, I've been updating things because I have to update these slides each semester. The laws always change. All right, so soon the Supreme Court will hear the New York State Rifle and Pistol Association versus Corlett case. And the issue at the focus of this case is similar to gun control measures in a whole bunch of other states. And this has to do with permits to carry firearms. So to receive an unrestricted license to carry a concealed firearm outside the home here in New York, where the case comes from, the person has to show proper cause, meaning a special need for self-protection. So 2 men challenged this law after New York rejected their concealed carry applications, and they're backed by a gun rights advocacy group. The U.S. Courts of Appeals for the Second Circuit upheld these restrictions, so now it's going to be in front of the Supreme Court. So you can see some steps a little bit, further, going above and beyond Heller and Chicago. Many people anticipate that our current Supreme Court, which has 6 conservative members, will say that these restrictions in New York are unconstitutional, that the result will be a Supreme Court case saying that you don't have to have a specific need for self-protection, just that you basically want to have this type of permit, either concealed carry or open carry, and that if you pass the background checks and have no criminal history, along with the other requirements, that will be good enough. So those are the predictions about this New York State rifle case. If you want to look at different state-by-state approaches, I invite you to look at this NRA report card state-by-state, and to also look at the Gifford Center scorecard state-by-state. And it will give you sort of a compare/contrast point of view of how these individual states are rated, because the NRA, of course, is going to be coming from a point of view that doesn't like gun control, and the Gifford Center, which is centered around, a gun control advocacy point of view is going to look at things differently. And you can compare and contrast, a state like Massachusetts that has a lot of gun control with a state like Texas, which does not. All right, this has been long enough of a voiceover or PowerPoint. Please feel free to check out any links that I didn't have time to go into.